Hi, this is Jim Cunningham, and we're going to talk about incapacity savvy planning for the inevitable. Well, it's about 80% inevitable because there is an 80% probability of some type of incapacity before death. And we're talking about Americans here. And it's, something that's 80% probable. Yeah, you probably need to plan for it because it's probably going to happen. If it doesn't happen to you, it probably happened to someone you care about. You might be watching this saying, gosh, what happens if my parents can't do for themselves? If, sort of the parent becomes the child and the child becomes the parent, or what about a spouse who has a diagnosis? Like, where is this going? How should these affairs be managed in these situations? And what happens when somebody becomes incapacitated? What is the legal effect? How does all this work? How does it change your living trust? What about things that are inside of your trust and things that are outside of your trust that maybe shouldn't even be there or happen not to be there? So, disclaimer, I'm a lawyer. I'm talking. This is not legal advice. We will talk about all of this. I'm Jim Cunningham. I'm your speaker. I've been an attorney for well over 25 years, and I'm a certified specialist in estate planning, trust, and probate law. We have offices throughout California. I'm a real estate broker, securities and insurance licensed, as well as a pilot. And these are our current attorneys in our firm. We are devoted entirely to helping small business and families with all things tax, estate planning, real estate. So all those things that are transactional in nature, not litigation. So incapacity planning for the inevitable. What are we talking about? Well, today, the day we're doing this recording, September 21st, happens to be World Alzheimer's Day. And a diagnosis of Alzheimer's can lead to incapacity. Just because you're diagnosed, as we'll see, doesn't necessarily mean you're incapacitated. So if you have a loved one with a diagnosis does not necessarily mean they can't do all the things that other people do merely because they have this diagnosis. So incapacity, again, not disability. What are we talking about? So if somebody is mentally functioning, that's not what we're talking about. We're talking about an impairment, and we'll kind of get a little bit deep. The probate code in California defines this pretty robustly, and this is what any judge would look at, any probate judge, and we'll explain why the probate judge is involved. But the real question you might be asking yourself is, who makes medical decisions, and how does that work? Who makes the financial decisions? Those are the two camps of decisions that the law divides, is who's taking care of the person and who's taking care of the person's assets, essentially their financial assets. And where do these assets go? How are they handled? We'll talk about paying bills. That's a very important one. And sometimes people step in it. So what is incapacity and what is it not? Like we said, we're talking mental incapacity. If somebody is mentally incapacitated, and we'll kind of dig deeply on what that means, we have to ask ourselves, who makes medical decisions for this person? If this person is unconscious, right? So you might go in for a surgical procedure and they say, hey, in the event that you're non-responsive, yeah, because you're under an anesthetic, right? Maybe a general anesthetic, who would be making healthcare decisions for you? That actually is an example of incapacity, albeit, you get your capacity back once you've recovered from surgery. Who makes the financial decisions? Who makes those? Is the agent under the durable power of attorney? Is it the trustee? We'll talk about that. And where are the assets? How are the assets handled? And who decides, right, if a person's mentally incapacitated? Spoiler alert, a lot of times it's a physician, and sometimes documents say 2 letters from doctors or letters from 2 different doctors. And the second doctor's like, why am I writing this letter? That, Dr. Smith has already said this person's incapacitated. Why is Dr. Jones having to write this letter? Well, it's because what the legal documents sometimes require. So I would say, if there's any homework in this might be the first element of homework. Look at these documents and figure out, does this say 1 doctor or 2 doctors, or, should it even be a doctor? We'll talk about that. And what we're talking about here is often the twilight period of life. And the reason that I use the term twilight is, sometimes as the day is ending, you're like, is it really, the sun is set, right? Is it dark yet? Well, no, it's twilight, right? The sun is set and the day is ending and the evening's beginning. And this is that sort of twilight period between capacity and incapacity that we're talking about. So it's many times not a bright line. Many times it is looking at the entirety of the situation. And if an elder, the term we use is not compliant, which really sounds horrible. If an elder is not compliant, the family may have to go to probate court, right? If the person says, no, I'm going to handle my affairs to the bitter end, sometimes in my practice, sometimes it's better to let those people just kind of give it a little bit of time, because sometimes these things sort of self-manifest and they become, obviously unable to handle their affairs. One issue there is if you try and help too much, sometimes you can push the elder away. So think about, if you know somebody who's maybe aging in your life and you say, gee, this person really needs, they need to bathe, they need to eat properly, they really shouldn't be driving, they should, have all these other things that are going on. If that person is not compliant, if they're resistant, sometimes the act of helping them can drive them away. This is not legal. I'm just going off of real world experience. So what is incapacity? What is it? Well, incapacity is defined in the law in California. And where we go to that is Probate Code Section 810. That's where we start. So something to understand, there is a presumption of capacity. So in California, every human being that's walking around who's 18 and over is presumed to have capacity to make decisions and be responsible for their actions. I mean, this is a basic foundational principle of law. You are responsible for your own actions. Now, you're responsible for your own actions until somebody says, well, you're not responsible because you're incapacitated. Okay. So if a person is flailing their arms, but they're mentally incapacitated, they're not going to be held legally responsible necessarily for those actions because it's not really voluntary. So, but again, everyone starts out as having capacity, or some people say capacitated, which I think is a made up word. And it's very important to understand that a mere diagnosis of a condition does not equal incapacity. So a person's mental or physical disorder a person with a physical or mental disorder may still be capable of contracting, signing up for cable or something. I don't know, contracting, making a contract, buying something, conveying. This is typically transferring real property, deeding property, marrying. That's a big one. A lot of people, their one parent passes away and the other parent, they kind of look at their aging parent. The aging parent says, I'm going to go marry so-and-so. And you're like, wait a minute, like this, hold on. Do you have capacity to do that? So unless a court says you don't have capacity to get married, you have it. Making medical decisions, that's an important one. And then executing wills and trusts, which does not mean killing wills and trusts. Executing is the legal term for signing a will or a trust in a legally binding manner, and performing other actions. So that's defined in California Probate Code Section 811. Now, it's very important to understand if an elder is compliant, right? Let's say an elder becomes incapacitated. You go to the doctor says, yes, mom is incapacitated. You can take that letter with some of these other documents that we'll talk about. But when the elder says, no, I want to do things my way, it's my life, I'm an adult, and kind of everyone in the world's like, this person's incapacitated, what do? You may have to end up in a conservatorship, and we'll touch briefly on that. But a probate court judge ultimately determines whether a person has capacity or not. So that's the court you go to. It's not a normal civil court. It's the probate court judge. And a probate court judge can find that somebody is totally without understanding or of unsound mind or suffers from one or more mental defects. And they can find that it's so substantial that under the circumstances, this person should be deemed to lack legal capacity to perform a specific act, maybe marriage, a specific act, or just all acts in general, right? This person is so far gone, they cannot make their own healthcare decisions, but maybe they have enough capacity to get married, for example. I mean, that seems kind of inconsistent, but the important thing to understand here is that a judge ultimately has that authority to make these various findings. The high probability is you don't even know a probate judge. So isn't it kind of crazy that if it's you or a loved one, somebody you don't know is going to go through some mysterious process and decide for you? Well, this is why a lot of people do estate planning. And so this is why people, setting aside the case of a non-compliant elder, typically, many times all these problems can be remedied through proper planning, and we will cover that. So a judge is not to rely solely on the diagnosis, but a judge has to rely on evidence. So the difference between a diagnosis and evidence, a diagnosis is evidence. I suppose you could make that argument, but a judge is also going to want to see, what is this person doing or not doing? What are some other things that are going on? What are the manifestations of their actions? And that judge ultimately decides if a person has capacity or not. So a judge can determine if a person is of unsound mind or lacks capacity to, again, make a contract, make a conveyance, which is deeding property, marrying, make medical decisions, or sign a will or a trust. And it may be the judge can say, yeah, this person can't get married and cannot contract, but can sign a will. I mean, I suppose you could craft a hypothetical like that. So it's very important to understand that this is a very nuanced area of the law. Evidence of a deficit is required, and this is really important, a correlation between the deficit and the decision or acts in question. So if somebody says, I want to sign this, enter into this agreement that's really grossly one-sided against the elder, a judge may look at that and say, you know what, this person did not have capacity when they entered into this agreement based on these factors, and so we're going to void the agreement, for example. So that's where this comes up. So what is a judge going to look at? A judge is going to look at alertness and attention, including one or more of the following: the level of arousal or consciousness. Is this person engaged? Are they paying attention? The orientation to time, place, person, and situation. And this is where you'll hear people ask, what month is it? What season are we in? Who is the president? And, who are these people? Where are you? Are you in a court? Those sort of things. I mean, not necessarily a leading question, but they're going to ask them, that a judge will, to determine their mindset, ability to attend and concentrate, basically to follow what's going. So that's one class of decision making. And then there's this other one, which is information processing. And this is including short and long-term memory. So just because you have some short-term deficit does not necessarily mean categorically you're incapacitated, but this may go to ultimately a judge or somebody else saying, or physician saying this person's incapacitated. Ability to understand or communicate with others, either verbally or otherwise. So if they're not able to communicate, I would say that's a negative. Recognition of familiar objects and familiar persons. If a person does not recognize their family, that means they're more likely to be incapacitated than if they recognize their family. And as I'm going through these examples, you might be thinking of, maybe it's a loved one you have, and they go, because I'm going through this right now, just frankly, with my father-in-law, is he's in declining health. He has a diagnosis of, it's probably Alzheimer's, although it's kind of hard to nail it down. And this is really hard. It's tough on the family. It's tough on, this is not an easy thing to go through. And if this is resonating with you, there is something that you can do about it, right? I mean, this is why you're watching this. This is why you're listening to this. Is there is something you can do when a person becomes incapacitated. And we're talking about now what is incapacity. We will get to the things that you can, that you should and should not do. Ability to understand and appreciate quantities, ability to use reasoning for abstract concepts, ability to plan, organize, and carry out actions in one's own rational self-interest, and ability to reason logically. So then there are two more classes. One is thought processes. Are there deficits in the thought processes? Is it severely disorganized thinking, hallucinations, delusions, uncontrollable, repetitive, or intrusive thoughts? Then ability to modulate mood and affect. So this is there a pervasive or persistent recurrent state of euphoria, anger, anxiety, fear, panic, depression, hopelessness or despair, helplessness, apathy, or indifference? And that's inappropriate to the degree to the individual circumstances. So sometimes it's appropriate. We all went through COVID, and I think we all had some of those during COVID. But is it appropriate to this person's current situation? So those are really the four classes that a judge is going to look at. It's very important to understand. Ultimately, a judge decides whether a person has capacity or not. Now, this must significantly impair the person's ability to understand and appreciate the consequences of their actions. And the probate court may take into consideration the frequency, severity, and duration of the periods of impairment. So if it's fleeting, and this is one of the challenges we have with clients who have typically adult children with mental health issues, is many times these people cannot care for themselves. The person goes on their meds and they're okay, but it's when they go off their meds, now, you can't compel them to go back on their medication. And so we'll talk, there's a conservatorship specially for that. So that's a difficult kind of outside the scope of what we're talking about here, but still very important for many people. Again, the mere diagnosis of a mental or physical disorder is not sufficient in and of itself to support a determination that the person is of unsound mind or lacks capacity to do a certain act. Conservatorships. Conservatorship is also known as an adult guardianship, or a guardianship of an adult in other jurisdictions. In California, there are two classes of conservatorships. There are probate conservatorships and mental health conservatorships. A mental health conservatorship is a situation where somebody lacks the ability, maybe they're gravely disabled, and that meaning due to the mental health disorder, a person's unable to care for their basic needs, such as food, clothing, or shelter, and unwilling or incapable of accepting treatment voluntarily. We have a huge homelessness problem in California. Many of those people who are experiencing homelessness fall into this category. And, many don't, right? But it's a mixed bag. And so there is a conservatorship specifically for this type of person, and it's the least restrictive possible. A judge is going to work with that. That is on the mental health side. Let's talk about what we see more with the elders, and that's kind of the what we're talking about here, which is the probate conservatorship of the person or the estate. Now, sometimes it can be the person and the estate, but if, for example, an elder or an adult is unable to care for their own physical health, food, clothing, or shelter, that means a conservatorship of the person. If they're unable to care for if they're unable to manage their own finances, resist fraud or duress, menace, undue influence, then that's a conservatorship of the estate. Sometimes you will see those together, frequently together. The whole idea, and this is done in the probate court, the whole idea is to avoid this. So if a person, if you have a loved one or you, and you say, I don't want my family to go through this. I don't want my family going to probate court. I don't want all this publicity and all these people involved. There is something you can do. You can do a revocable living trust centered estate plan. So assuming you have that in place. So what this means is a living trust is like a bucket. So I set up a living trust, and there's a handle. I'm the trustee. My son is successor trustee. Right, he will hold that handle when I'm deemed incapable of holding the handle. I put my home and my bank accounts and my savings account, my investment account. I put that into my bucket. That's my living trust bucket. IRAs, 401ks, annuities, 403bs, TSAs, life insurance, and annuities stay outside of the bucket. There are a lot of reasons why. We cover that in other webinars. Those assets stay outside of the bucket. Those are handled slightly differently. When I stop being trustee, so if I am unable to manage my own affairs, I have stroke, dementia, Parkinson's, Alzheimer's, whatever it may be, I have this diagnosis and it's getting worse, and I've reached this point where I can no longer handle my own personal affairs. I can resign as trustee, which is one way to do it. I can resign as trustee and effectively pass that bucket to my son. So I'm no longer holding onto the handle. My son, who's the successor trustee, is now the trustee. He's holding on to that handle, and he's using the money in that bucket for my benefit, not his benefit yet. Of course, when I die, he's going to get that. But when it's in that bucket and I'm alive, he's holding on to the handle. My son, who is named successor trustee, is now the trustee, and he's using those funds to pay for my benefit. That's exactly what we're talking about here. So I'm incapacitated. My son is now the trustee. What are some things he needs to do? Well, kind of Captain Obvious stuff. You need to locate the living trust. And the will, because everyone dies. You want to make sure you have that will. The durable power of attorney for property management and personal affairs. Sometimes it's a uniform statutory form power of attorney. Sometimes it just says power of attorney. The important part here is durable. Powers of attorney can be durable or non-durable. What's the difference? A durable power of attorney says that even though I'm incapacitated, even though I can no longer do for myself, this power of attorney is still valid. Some powers of attorney say that when I become incapacitated, the agent or the attorney, in fact, the person who's acting on my behalf, can no longer serve as the agent under the durable power of attorney. Well, for estate planning purposes, I can see why that might be good for like business purposes. But when it comes to estate planning purposes, of course, you want these to be durable. Sometimes we see them and they're not durable. I kind of like, who wrote this? Maybe it's something a client got off the internet. But it's very important that this power of attorney be durable, meaning it endures past disability. Now, the reality is when a person dies, that power of attorney, that power that the person who was living that gave to the agent, when that person dies, that power dies with the person. So a living trust continues on. It lives. A durable power of attorney dies when the person who creates the durable power of attorney dies. So takeaway number 2 from this would be durable powers of attorney are valid until the death of the person who created that durable power of attorney. So in this case, it would be me with my son, or maybe it's another parent for a child. Advanced Healthcare Directive is a document that says in the event I can no longer make healthcare decisions for myself, then this other person makes them. Obviously, if you're making healthcare decisions, I'm a living, right? So I'm alive, but I'm not making healthcare decisions for myself. My son makes those healthcare decisions for me. I've named him my agent under my durable power of attorney for healthcare. California has added surrogacy law, and that kind of confused stuff for a while for lawyers. Kind of, when things change, lawyers get a little grumpy. And basically what it says is you can have an advanced healthcare directive, and you can go into the hospital and say, if I say, well, my son is my agent, my healthcare agent, and I go in with my daughter to the hospital, I can say, well, I want her to make healthcare decisions for me. Maybe my son's not available. You can see where it gets a little murky, especially if you have an advanced healthcare directive, and then you might be orally designating somebody. That's kind of outside of the scope of what we're talking about here, just something to be aware of. Then you need to carefully review these documents. Now, here's the problem. These documents are written in legalese, and unless you're a lawyer who understands estate planning, just because you're a lawyer doesn't necessarily mean you understand estate planning. You need to make sure that these documents actually give you the power that you need. You make sure they're complete. Are they signed? I would say one of the biggest problems we see is that people, they show up at our office and they say, Mom and Dad had a trust, and they bring in the document. And they go, oh, well, that's the draft. That's the unsigned copy. But the original's around here somewhere. Well, you need to locate that original, that sort of ink signed original. Look at the trust. The trust does not always should identify a successor trustee, and the durable power of attorney for property will designate an agent under the durable power of attorney. So a living trust doesn't necessarily have to designate an agent, but a durable power of attorney, I mean, why would you do that without designating an agent? I suppose you could leave that blank, but I would say in most instances, a durable power of attorney does have a person named. We do see some trusts that do not have a successor trustee named. Maybe the person couldn't decide when they set up their living trust. And then the advanced healthcare directive typically has an agent name. Now, I will tell you, California, you can go online and get these. The advanced healthcare directive is something, if you're a Kaiser patient, they provide those. The one in Northern California is different than the one in Southern California. I don't know why. You'll have to ask Kaiser. The California Medical Association provides these, I think, for $1. If you do a good Google search, a lot of counties have posted the advanced healthcare directive. That's kind of a freebie. In our firm, we do use that document. That is the statutory form, because that's what the medical community is used to seeing. And we kind of walk through the decisions with our clients. Some of these are, do you want the plug pulled if you're a goner? Do you want organ donation? And these are things that's part of the counseling process and doing estate planning. So if, I become incapacitated, my son is successor trustee, can he just start acting? What documents is he going to need, right? With a living trust, typically it requires the acceptance by the successor trustee, meaning I accept, and a new certificate of trust. So that typically it's an affidavit or some other type of declaration under penalty of perjury that's notarized that says, the trustee says, yes, I am the trustee. This person's no longer the trustee. If I resign, it's really easy because I sign it and it's notarized, right? If I don't resign, that successor trustee might need a letter from a doctor. It depends on what the living trust says. So a living trust can say a letter from one doctor or a letter from two doctors. So if my son were administering my trust, and we'll talk about what that is, if he wants to serve as trustee, he's named successor trustee. If he wants to jump in and to hold that handle of the bucket, he has to prove that he's successor trustee. So he'll need his photo ID. He'll need either my resignation or maybe that letter or two from doctors. Some living trusts say that a committee of people decides if I'm incapacitated. So you would need that document that those people would sign, again, with a notarial acknowledgement. And a new certification of trust. A new certification of trust says that I'm the trustee. This is the taxpayer identification number. It's typically going to be my social security number while I'm alive, okay? And the residence of the trustee. A little hint here is if you name a trustee who is not a resident of the United States, that is going to be a real problem. That will be deemed a foreign trust. It's going to cause a problem with brokerage accounts and some bank accounts. So I'd really encourage you to if you only have a foreign or a non-U.S. resident, even if they're a citizen, a non-U.S. resident trustee, you really want to chat with your lawyer. And if you don't have one, you can certainly reach out to us about getting a U.S. resident trustee. So acceptance by the trustee and certificate of trust. And then so a living trust handles everything that's in the bucket, handles my house, assuming my house is titled in the name of the trust. And we covered this in a previous webinar about funding your trust. House is in the trust, bank accounts in the trust. All these things are in the trust. Well, I have stuff that's not in my trust. What about life insurance? What about my IRA, right? Who's going to handle that? Well, that's the agent under the durable power of attorney handles that IRA. So If I'm in a nursing home and my bill's $12,000 a month, which a lot of nursing homes are $12,000 a month, by the way, how is that paid? Should it come out of the IRA? Should it come out of the living trust? Which bucket should it come out of? There are rules. There are proper buckets and improper buckets, and we'll talk about that. But it's the durable power of attorney, the agent under the durable power of attorney, who takes those actions. So remember, you got your living trust that deals with living trust stuff that's in the bucket. Everything else is handled by the agent under the durable power of attorney. Many times those are the same people, and frequently they are. So, by the way, even if this is very simple, if somebody becomes incapacitated and you are the trustee or the agent under the durable power of attorney, you absolutely need legal advice. This is something you don't want to wing it. Not only do you have to follow the terms of the trust or the durable power of attorney, you also have to follow California law, which is not, California law is just out there. You also have to follow doctrine. You also have to follow, there's a lot of federal tax laws that you have to follow. So there's a lot that's in there that's not necessarily contained in the document. Some of the stuff actually does not make logical sense. And it's very important that even if it's a very simple estate, even simple meaning small, you would want to enlist the aid of a lawyer to see if you need legal advice, right? Because, a lot of times when we typically have an initial meeting on a trust administration or other type of administration on a power of attorney, a lot of people don't know what they don't know. So they come in, and many times if it's simple, we kind of give people guidance. These are the do's, these are the don'ts. And if you have any, take 2 aspirin, call me in the morning kind of thing. But other people are much more complicated and they need legal representation right from the get-go. So how do you know which camp you fall into? You don't. That's why you need to talk to a savvy lawyer. That's somebody certainly you could reach out to our firm and we can help you out with. If you don't have a lawyer, if you're already represented, then I would, certainly defer to your current legal counsel. So you verify the trust is funded or not. Okay. We're listing assets of what we're talking about here. What's in the trust? What's not in the trust that should be in the trust? And can you put that asset in the trust? So these are layers of complexity on questions. So if it's me and I have full capacity and it's my living trust, I should fund my trust. If I become incapacitated, should or could my son, who's now the trustee and agent under the durable power of attorney, fund that trust? You need to talk to a lawyer before you do that, because it depends. It depends on the nature, how that asset's titled. It depends on, is there a beneficiary attached to that particular asset? So it really does depend. And one thing we will cover is that under California law, when a person becomes incapacitated, assuming that they're the only person who wrote the trust, a single person, that trust under operation of law becomes irrevocable. Now, it's not irrevocable by the terms of the trust, but again, I mentioned you have the trust, you have to follow the trust. You also have to follow California law as a trustee, person who's holding onto the handle, right? This is the successor trustee. Once they start serving trustee, they're holding onto that handle. Not only must you follow the terms of the trust as written, you must also follow California law. California does say that when a person loses their capacity to make a trust, then that trust becomes irrevocable. So very, very important fine point of law there. Assets that typically go into a trust, again, are real estate, bank accounts, stocks, bonds, brokerage accounts, mutual funds, IRAs, 401ks, annuities, life insurance typically stay out of the trust. Well, let's talk about something that is a very common question: paying the bills. Order of liquidation and sale of specific gifts. So these are two kind of interesting things that people don't necessarily think about. I want you to remember that if you're a trustee or an agent under a durable power of attorney, that person, if that's you, is 100% personally liable for all acts and omissions. Now, an omission is something you didn't do that a judge later says, you know what, you probably should have done that. And because you didn't do something that you should have done and there are damages, you're going to have to pay out of your own pocket, trustee. Sorry. Under California law, incapacity makes a revocable living trust irrevocable by operation of law, and the order of liquidation rules apply. So mom has a living trust with $100,000 in it. So let's just hypothetical. Mom's got a nursing home bill of $12,000 a month. Mom has a living trust with $100,000 in her living trust. She has a payable on death account to son for $100,000, meaning she has $100,000 in an account, and that account says mom, POD, or payable on death, son. And a lot of times when she gets her statement, that's what the statement says. And she's got $100,000 in her own name individually. Which bucket should the trustee pay the pay the nursing home bill from, right? Well, if it's a trustee, the only thing the trustee's going to have access over is the trust. But if the trustee is also the agent under the durable power of attorney, that agent, who's the same person, that agent under the durable power of attorney could take from the POD account. The agent could take from the account that's just in mom's name. The answer, by the way, is it's mom's account that's just in her name. So if the trustee, durable power of attorney person, right, who has both capacities, if that person starts drawing down on the living trust and the beneficiaries of the living trust are different than maybe mom's estate, you might have a problem. If you take $100,000, let's say you pay $50,000 in bills out of the POD account to son, what's son going to say when he says, hey, wait a minute, there was $100,000 in mom's name and $100,000 in the POD account, and you drew down on the POD account and left $100,000 in mom's account. Wait a minute, I'm going to sue you, trustee. I'm going to sue you, agent under the durable power of attorney, for taking the money out of the wrong bucket. By the way, this is a real legal issue, and it typically comes out way after mom's dead. Okay. So typically you can see it when mom's still alive. It's actually increasing, but this does sort of see the light of day at the very end. Dad has a living trust with $100,000 in cash and $100,000 in Apple stock. Dad's living trust says that on the death of dad, son gets the Apple stock and son and daughter split the $100,000. Can the trustee, let's assume dad's incapacitated, can the trustee sell the Apple stock to pay the nursing home bill and keep the cash? So think about that. There's $100,000 in stock that's going to son, and son and daughter split the $100,000. Well, if daughter's the trustee, what do you think she's going to do? Well, wait a minute, I'm going to sell the Apple stock, right? Can she do that? Maybe, maybe not. Should she do it? I don't know. Well, what if she does it, right? Well, what ends up happening is those gifts, if dad were alive and says son gets $100,000 in Apple stock and dad sold that stock while he's alive and has mental faculties, that gift is deemed, it goes away, it's redemption. But if dad's incapacitated, that trust is now irrevocable under operation of law. So if the daughter sells that $100,000, she very well may have to account for that money, and the son still gets the value of that stock. You see where I'm going with that? So very, very important. Just be aware that there's an order of liquidation of accounts. This is not easy. And most people don't just have a big pile of cash in their trust and that's it. A lot of people have different assets. So you really do need to pay attention to this. Okay, there is a legal process after you become incapacitated. That is called trust administration. This is the worst word to describe it, because when I say this word, normal people are like, Jim, I have no idea what you're talking about. Trust administration. What? I don't even know what a trust is. What are you talking about? Trust administration is like probate without a court supervision. So while somebody's alive, it's a lot like a conservatorship. Okay, it's a lot like a conservatorship without the court oversight. Well, maybe without the court oversight, unless somebody sues and brings a trustee into court. This actually can be more complex and more expensive than potentially could be more complex than a conservatorship matter, especially if you haven't paid enough attention to the living trust while you're alive. And we've done this recently. We've focused a lot on funding your living trust. Very important to keep, if you have a living trust, it's very important to keep it appropriately funded. So if you have real estate, make sure that real estate's in there if it's supposed to be in there. Make sure things that are supposed to be in the trust are in the trust. If they are not in the trust, you can see this order of liquidation issue. It starts complicating things. So it's very important to pay attention to your estate plan and the scope of work. I will say in a trust administration, it varies with each case. Mom with $100,000 in a bank account, fundamentally less complex than, mom who's owning a business and multiple homes and rentals and businesses or whatever it is. That's just fundamentally different. So I would say that sometimes lawyers give bad advice. These are typically, if you're a lawyer watching this, if this is an area of specialists, by the way, estate planning is an area of specialists. Most of the areas of law are specialty areas. And so if you don't have substantive knowledge, you really, you shouldn't be doing it. And CPAs can give bad advice. What do I mean by that? Sometimes CPAs will say, oh, well, you don't need to do that, or take this shortcut or do that shortcut. It may work. And the problem is, when it doesn't work, that's when you come back to the lawyer. That's when we see the infections, right? It's no different than the doctor saying, look, you should do this. Otherwise you could have an adverse reaction to it. And then the doctors see the adverse reactions, where that may be a 1 in 100 instance, whatever it is. But you can see in my view, I'm probably a little bit biased in presuming that things will go wrong, which is not necessarily a bad thing. So each professional focuses, I think, on their core competency. And many times some of these things fall between the cracks. So a lot of times somebody will ask, a client might ask a CPA a question that they really should be asking their trust attorney. And somebody might ask a trust attorney a question that they should be asking their financial advisor. So it's very important for those three professions, those three disciplines to really work together. Many of these do fall through the cracks. And frankly, at the end of the day, who ends up holding the bag? The trustee and the agent under the durable power of attorney. Typically not the professionals, but it's the trustee ultimately who has responsibility for that. So pay attention as a trustee, assemble your A team. We've talked about this in other webinars. It's like that show from the 80s. You got to get your people together. And when we work on bigger projects, I like to have everyone's cell phone number so I can text, I can call quickly. Professionals have a lot of gatekeepers. And if it's an important enough transaction, you want those people working together. Remember, the person in charge must protect and manage the assets in a trust administration, and that trustee is 100% personally liable for any misstep. Very important to understand, the trust assets are not the trustee's personal assets, okay? If a person, sometimes you have to notice beneficiaries, typically when there's a change in trustee if someone's alive, but there's typically a notice requirement that can exist even when somebody's alive. And again, we talked about paying the bills, and then the specialty assets you really have to pay attention to. So what about the power of attorney? Okay, a durable power of attorney for property management and personal affairs and a uniform statutory form power of attorney. We're talking about these kind of together. This is where you, if you're doing this document, you appoint an agent. Sometimes it's called an attorney in fact. It's very confusing. We started using the term agent, not attorney in fact, because people were like, wait a minute, I'm appointing you as to do stuff for me. It's like, no, attorney in fact is different than attorney at law. But this person acts on your behalf, sort of stands in your shoes. This is an agency authority document. What does that mean? Whatever rights you have as a human being, you can delegate those rights to somebody. You can delegate everything, or you can be selective. But this is fundamentally different than a living trust. A living trust says that there's this trust, and whatever's in this trust, the trustee has dominion and control over, okay? Has control over these assets. And when you designate a person as agent under your durable power of attorney, it's like whatever you can do, they can do. So it's significantly broader, which is a little deceptive because sometimes these are 2 pages long, and your trust might be that thick, and then you have a 2-page document that may give that person significantly broader authority than your living trust. Again, durable powers of attorney expire at death. Your ability to appoint your agent for your personal matters dies with you if you're the one creating it. This is not the case with the trust. A trust survives you. A living trust, a durable power of attorney does not. And in a sense, when the durable power of attorney stops, what replaces it? It's the will. So the will names an executor. Typically, these are the successor trustee and agent under the durable power of attorney and executor are typically the same people. But that's the durable power of attorney ends, and typically the executor under the will picks up that authority. All right. Incapacity preparation for healthcare decision-making and long-term care. Medical decision-making. The healthcare directive is the document. Advanced healthcare directive. Advanced healthcare directive is another way of saying it. Healthcare surrogate in other states. When should a medical directive be created? I think everyone should have a medical directive because you will have a period in your lifetime, high probability, when you will not be able to make healthcare decisions for yourself. And you may not have the ability to designate somebody if it happens quickly. This is part of the estate planning process. Now, can it be done independently? Yes. If you're a Kaiser patient, I think every time you go to the hospital, they make you sign a new one. At least that's what I've heard. And a lot of times these might be done more frequently, frankly, and it's a form, right? And so if you change your mind, it's not that big of a deal to change it. Changing your living trust can be a much bigger process, but the medical directive and the medical decision-making, a little bit more fluid, easier to change. Typically this document, so if you're like, wow, mom's sick, where do we find this? Typically it's with the other estate planning documents. So when a person goes to a lawyer, it is customary for the estate planning lawyer to do a living trust, a will, and the powers of attorney for property and healthcare. Many times those are in the same bundle. So in our firm, we use a binder, a 3-ring binder to help people stay organized. Other attorneys might use a different format, but just look for kind of a thick stack of documents wherever the important papers are kept. We keep digital copies of everything our clients sign. So many times the parents or the kids will reach out to us, and certainly if the kids can evidence their authority, then we can go ahead and provide the copies of those documents because sometimes they're just not available. The Advanced Healthcare Directive is the document. It's a legal document that says I give to this person the ability to make healthcare decisions for me. A POLST is a physician's order regarding life-sustaining treatment. That is different. That is a medical directive. That's that pink sheet. It's almost like a donut box, right? That pink sheet. And a lot of people put this on their front door, right? They might be at an assisted living or nursing home or even their residence. They put it on the door, maybe just inside the house. It says, look, if my heart has stopped, do not resuscitate me. It's like a DNR order, but they don't have to go through a person. So if you don't have, and I'm not saying get a POLST, but if a person does not have a POLST and those EMTs show up, they're going to do everything they can to save you, unless you have a POLST, which says, wait a minute, I've made this decision not to provide this medical service or whatever the range of medical services is. And so that, in that sense, that's the order part of it. That's different than the legal document that empowers somebody to make those decisions. So this is you saying yes or no on this life-sustaining treatment. HIPAA authorization has medical private. That's a medical privacy document that gives authority to somebody else to access your medical records. So medical privacy, it's illegal for a medical provider to share your confidential medical information with somebody else unless you have authorized somebody to receive it. And then you really should think about end-of-life decision-making. I know it gets a little grim, but if you don't really sit down with the people, whether in writing or orally or whatever it is, if you're not communicating your desires, I think it makes it harder on the people who care about you, because if they don't know, they're gonna be like, well, what would mom or dad want? So it can be really tough. But it's good to make those known. Those are typically included in the Advanced Healthcare Directive, or living will is another way to do it. What about long-term care? Long-term care is a bundle of services provided to meet a person's health or personal care needs during a short or long period of time. So this can be long-term care, can be for a short term, but the idea of long-term care is, look, this is something where we have these impairments of these activities of daily living, and there's 6 of them: bathing, dressing, toileting, transferring, which is like getting in and out of bed, eating, and continence, which is controlling bowel and bladder function. If you have an impairment of one of these activities of daily living, you may need long-term care. If you have 2 impairments, you might need a higher level of care. If you have 3, you're going to need a higher level of care. And we'll talk about long-term care insurance. Many of them do require at least 2 impairments of activities of daily living. Some older ones require 3. Long-term care helps people live independently and safely as possible. So the idea is, most people want to stay at home. They might need someone to help them bathe and eat, right? And if I get some help bathing and I get some help eating, I can stay at home for a longer period of time. That's really what everyone wants, right? No one wants to go to an institution. They just don't want to do that. You want to live as independently as you can. It's what most people want to do. Too often, if you don't have long-term care insurance, this happens. This is unpaid by a family member or friends, and this can include adult daycare, nursing homes, in part. But really, where I've seen the strain in families, and I've seen this personally, is it is typically one member of the family who kind of has the laboring oar. Quite often, it is the daughter who ends up with the laboring oar. Not always, but frequently the daughter. A lot of times, it's the person who's closest, maybe physically proximate. And there's some other options out there. There's some free or fee-based meals. Meals on Wheels is one of them. Adult daycare. There's some transportation that's free or fee-based. And I know my mother-in-law for many years went to adult daycare, and that was really good for her. Give a little bit of respite for my father-in-law. So these are some things that something to think about. And if you're going through this, there are plenty of social services out there, and really do pay attention to this, because the idea is you want to keep people in their home for as long as they can. There are triggering events. A lot of times it's this triggering event that brings on the long-term care need. It could be a bad fall, a heart attack, a stroke, and long-term care can also develop gradually. And maybe this is, a cognitive impairment, but typically it's going to be precipitated by some type of fall. That's what we see most common. What about long-term? It's hard to predict who's going to need it and the type. It's tied to age. Women live longer. Maybe women have a greater need for long-term care. Single people typically, statistically, have a greater need for it. Bad choices, obviously, diet and exercise can impair that. Your health and family history also plays into it. Sleep, that's a very important one. But you really should think about what's your long-term care plan. And if you're watching this, if you're listening to this or watching this because there's someone in your life who's aging, you really need to think about this stuff. So long-term care insurance, there's a way of insuring the risk of long-term care. And there, a lot of people buy long-term care insurance. The old way is to pay, monthly. And I know for those of you who are PERS employee or PERS retirees, they've kind of raised premiums or cut benefits. They kind of missed the mark on pricing it. That's the old way, is monthly. The new way is to write like a check. Like we have an example, Betty. She's got an old policy of life insurance with $100,000 cash value. Betty can take that cash value life insurance and exchange it under Internal Revenue Code Section 1035 into a different type of long-term care policy, which is an insurance policy with a long-term care rider, and that gives her $300,000 in long-term care benefit. And if Betty doesn't use any of it, that $100,000 goes to her kids. So that is the new way of doing it. That is the single pay versus the pay monthly. And a lot of people, they say, look, if I can just take this old life policy and maybe 3X for long-term care, great. I just don't want to have to pay the premium, right? So that's where a lot of people are. And you could certainly do this if you had $100,000 in the bank. Betty, if she had $100,000 in the bank, she could do the same thing and get the same coverage. So I would really encourage you, if you're watching this and you say, gee, I need this, make your wishes known. If you're working with an elder or a loved one, it's very important to document what those wishes are, because there can be conflict in family, like shocker, right? If your family does not get together at Thanksgiving because there's no way they're going to get together, you might want to think about having this a little bit pretty detailed. So if your family gets along, less of an issue. I think I'm just going off my experience, but if you're sensing there might be conflict in your family, probably a good idea to nail this down. You can do a prepaid funeral policy as well, which prepays. You can say, hey, I'm going to be buried in a whatever, I'm going to be cremated and my ashes scattered or something like that. All right, it's $5,000, and you can write that check so that your kids don't have to, plan that when you're gone. So that's pre-need planning. So again, make your wishes known. Just part of the estate planning process. So if you're watching this on YouTube, subscribe to our YouTube channel, go ahead and click the bell. And if you click that bell, you will be reminded of or be alerted when we post our content, which is typically 6 p.m. Pacific time weekly on Thursdays. And everything you have seen here is not legal advice. So I probably should have put that disclaimer up at the front. So this is, if you're watching this, there's no attorney-client relationship that attaches. And if you would like more education, please visit our website, CunninghamLegal.com. Also, if you're watching us on YouTube or have never been to our YouTube channel, I'd encourage you to check it out. And also, Savvy Estate Planning, What You Need to Know Before You Talk to the Right Lawyer, is in its second edition. I would encourage you to buy that and read it. Kind of gets you prepared of all the questions that really not so much tax related, but these are just basic questions, fundamental questions that a lawyer will be asking a client that too often the client hasn't even thought about. Like if you're watching this and you're the client and you go to a lawyer, whether it's us or somebody else, that lawyer should ask you a bunch of questions. And a lot of times people are kind of blindsided. And we do have offices in Northern and Southern California, Auburn, Oakland Hills, Montclair Village, Sacramento, San Francisco, San Rafael, Walnut Creek, Pasadena, and Westlake Village. Next week, we have passive income streams, thinking beyond real estate. So there are methods of passive income that are not necessarily real estate, although real estate's a great source of passive income. So these are ways to get income get your money working for you, right? Pretty good idea. Again, subscribe to our YouTube channel, and I will open it up to questions. If you are watching this on YouTube, keep watching, because another video magically will just roll